information. You may proceed.
Thank you. May it please the Court, my name is Monica Brookman. I'm an Assistant Attorney General and representing the Attorney General in this matter. The Attorney General is appealing the Commissioner of Insurance decision to approve an unprecedented and substantial rate hike for the Massachusetts Fair Plan. The Commissioner made this decision without allowing appropriate review for a significant portion of the proposed rate, as well as allowing for this rate to significantly exceed statutorily imposed rate caps. The Massachusetts Fair Plan was created by the legislature so that those people who cannot get insurance for their property in the voluntary market had an opportunity to insure their property. Originally, this was designed for those in the inner city who were at the risk of vandalism and theft and arson. And more recently, these particular homeowners are on coastal properties because of perceived risk of hurricanes. Because this is a vulnerable population and these people have no other option but to buy this insurance, the legislature created this body, the Massachusetts Fair Plan, and only allowed its rates to increase after significant review by the Commissioner of Insurance. The voluntary market does not have this sort of review. The reason why this review is here is for those who have no other choice but to buy it, are not paying for rates, or are not paying for factors in these rates that aren't appropriate. And that's why the legislature created this review process. So they created 175C, which allows for which requires the commissioners to review this rate under the procedures of 30A. This calls for an adjudicatory proceeding and allows for intervening parties to test the evidence to assure that appropriate rates are being passed on to consumers. The commissioner did not do this here. The Fair Plan filed a rate in which a significant portion of the rate was not reviewed.
Excuse me, the brief for the defendant appellee claims that, written by the Special Assistant Attorney General, says that you have ignored the fact that everyone at the hearing agreed to the use of the loss data of the insurers writing homeowners insurance in Massachusetts in determining MPIUA loss costs and other related calculations underlying its filed rates. Is that correct, that that was agreed to by the Attorney General, by everybody at the hearing?
That particular loss data was agreed to. That's correct.
Okay.
But that was in response to our argument that she didn't consider voluntary loss costs when reviewing the overall rate, and that doesn't apply in this circumstance. It's not enough.
Well, do you agree that that the 5.9% cap was appropriately determined?
That's correct.
Well,
That wasn't contested.
Okay. Well, isn't the loss data one of the components of the 5.9% cap?
Right. Well, that's calculated based on premiums, not necessarily on loss data. The reason.
But isn't the loss data included in the 5.9%?
It's included, yes, but that doesn't imply that she considered it when she approved these rates.
But she would have had to have considered the loss data in determining the 5.9% cap, right?
In accepting that 5.9% cap.
And you agree that the 5.9% cap was appropriately determined?
That's correct. Right. That's correct. We thought the 5.9 was appropriate. But again, the rates exceeded that 5.9% with a significant problem of this rate. Those caps are legally imposed in this proceeding. There's nothing in the face of the statute that allows for the removal of those caps. However, the commissioner allowed those caps to be obviated by misinterpreting a statute imposed by the legislature in 2004. This misinterpretation was wrong as a matter of law. Those caps are still there, are designed to protect consumers from year-to-year rate shock. But the commissioner instead ignored them and allowed for a substantial hike.
Well, she didn't ignore them. She just disagreed with your interpretation of the statutory intent, and particularly the use of the language, was it notwithstanding the cap, the commissioner is to specially consider two other factors, which she did here, and she views that notwithstanding to mean that in addition to the cap, there can be additional raises.
Her interpretation was incorrect, and although she has discretion to look at vague statutes or to interpret vague statutes, this is not vague that these caps are still in effect. The notwithstanding language is just that, notwithstanding the existence of the caps, the fact those caps are still there, she is to just consider, not remove the caps, but to consider those particular factors.
Is there anything in the statute in Section 5C that requires her to explicitly consider, as Chapter 175, Section 113B requires the commissioner, to explicitly consider certain factors?
It doesn't say the word explicitly in that statute, but it's not necessary because there is no way to determine that the commissioner followed the law, but for the fact she would need to explicitly put it in her decision. And so she's required to describe how those particular factors, when she considers them, how it affects her decision. When she made this decision, she is required to hold a hearing and allow for this evidence to be tested before she approves the rate. She did not do this here.
Why do you say that? I thought there were lots of hearings here, lots of witnesses, lots of exhibits, lots of cross-examination.
That's correct, and that was for a rate filing that was disapproved.
Right, but disapproved with the very explicit, detailed caveat that it would be approved if the insurer, the Fair Plan, submitted a couple of additional changes, very specific changes. They did, and so it was approved. So why is that a problem?
Well, those particular changes included some substantial evidence that remained unreviewed. So
So is it your position? I take it what you're talking about is whether or not the Fair Plan actually bought reinsurance.
Well, there's a lot of issues involved, and one of them is
the one in your brief
whether or not they bought reinsurance, whether or not this reinsurance is in compliance with her original decision.
But you had a chance to litigate that question, didn't you?
This reinsurance purchase. Sorry.
No, go ahead.
This reinsurance purchase didn't happen till after the decision. Well, the
purchase didn't happen, but the discussion about a particular reinsurance policy and what was available in the market, that was all discussed at the first hearing.
It was discussed in theory, but this particular purchase and whether or not this particular purchase even complied with that original discussion is still unknown. But
that was all open to your opportunity to cross-examine the MPIUA on this question. You could have gotten into those questions at the first hearings, but decided not to.
We couldn't gotten into questions about this reinsurance purchase because it didn't happen.
All right. Can I ask you this? Can I ask you this? The commissioner said very explicitly that she would allow, I don't know, a $13.5 million total rate adjustment if, in fact, the policy of of costing no less than $17.5 million, blah blah blah, was purchased, and so then the reinsurer, or the Fair Plan, let me just call it the Fair Plan, submitted evidence that they had in fact purchased it, showed the $9 million down payment, the contract, and all that. And then the commissioner said, fine. Are you and I think that was done on August 11th, maybe? August 11th, for a rate that was to go into effect October 1st. Now let me ask you this. Did you after receiving that decision on August 11th, file some sort of petition saying we want to examine further whether in fact, in spite of the affidavit and the canceled check, this reinsurance was bought and it meets the criteria? Did you file some petition to sort of ask for more hearing on that?
She's required to hold a hearing under 175C because it is a new and revised filing, and particularly because it included new evidence. So
Did you ask?
We did not think it was necessary to ask for it because it was required. Now,
final decision to go into effect October 1, and you've got 6 weeks before it goes into effect to say, look, this is new evidence and we'd like an opportunity to examine it, so we'd like you to reopen it. I mean, isn't that very simple? We're now a year later and you want to undo all the rates, everything, and go back and start over again. Couldn't that have been raised back then?
As far as I know, every refiling the commissioner has ever heard allowed for a hearing, so those parties that were involved could test that evidence and determine if more discussion was necessary to determine if this refiling was incorrect. It was the first time, as far as I am aware, that she ever failed to hold a hearing, so we did not think it was necessary to point out that she needs to hold a hearing because it is clear from the law that a hearing is required on any filing.
Let me ask you this. Is it objectively determinable whether the reinsurance rates are reasonable?
I think it needs to be tested to assure that those rates should be appropriately passed on to consumers, and that's the point of these hearings. We cannot...
I don't think you're saying that it's not objectively determinable. You need to cross-examine on it.
I think that's correct.
All right, well, I thought her decision said $13.5 million, which is she would allow that if they purchased a policy that cost at least $17.5 million for reinsurance that would cover certain losses. They submitted evidence that they had now purchased for the upcoming year, October 1, 2006 to October 1, 2007, a policy that cost $36 million, right? So well within the criteria which she allowed. Are you suggesting today that you have a reason to believe that they didn't purchase this at all? This is a scam, and you want to get into that?
I think there's not enough evidence before us to even make that determination.
There's a contract, and there's a $9 million down payment, first quarterly payment. That was submitted back a year ago.
That's correct, but I mean, the reason these hearings we have these hearings is the fact that we need to test this evidence. You know, the MPIUA can't put the filing with an affidavit of its president saying everything in it is reasonable. We have to actually review the filing.
The commissioner found that $13.5 million was reasonable.
In the original filing, the MPIUA submitted evidence or asked for ratepayers to pay for a reinsurance cost despite the fact it did not buy any insurance. To justify this cost, they came up with
and
a
the commissioner
formula.
said no. And the commissioner
said no. They came
gotta buy it. You have to buy it.
They have to buy it. But when we had the hearing below, they only put in a formula to demonstrate a cost which they didn't actually want to buy. Just they wanted to demonstrate a cost to pass into the rates. We don't know if the new one that wasn't significantly tested because the argument below was that it shouldn't happen. I mean, that they should not be allowed to pass on this sort of cost when, consumers aren't getting this reinsurance cost. And she disapproved that rate based on it. Afterwards, the MPIUA submitted, purchase reinsurance, but we don't know, one, if it's fully compliant with the calculation in the original filing, or that they did buy it, or even if it is fully reasonably passed on. If it's determined in the second hearing that that reinsurance purchase is in fact unreasonable, she still needs to disapprove it, despite the fact she said $13 million may be reasonable. Because if there's something in that rate that shouldn't be passed on,
but all that's being passed on is 13.5, which she found to be a reasonable cost for reinsuring catastrophic losses over $520 million. She's already made that finding.
That was based on a reinsurance calculation of reinsurance that was never purchased. This is a new purchase that should be examined. We would ask what was in that reinsurance calculation. Did they actually purchase? Are we expecting them to find significant problems? We hope that's not the case. But the point of these particular proceedings is that the consumers, or Attorney General, as representing the consumers, can test this evidence so that the commissioner can make the determination that they are in fact reasonable. And that didn't happen here. We cannot allow significant portions of the rate to be left up to the industry to determine what is reasonable or not. This needs to be subject to public review.
I don't want to ask you to repeat the arguments that you've made several times, but one of the things that happens in proceedings, I know you think that you expected her to have hearings, but what struck me as a little unusual is she had an implementation date provided that they purchased through the insurance. You could either at that stage have said, fine, but before you sign off, we would like to have an opportunity to test, or when they came forward with the reinsurance and however much information they gave you, knowing when her implementation date was, you could have asked to have hearings. And in those, I mean, one of the things about these regulatory hearings is all kinds of pieces of the statute may be compressed or condensed when the parties don't object. I mean, these are very complex, and the parties try to get to the bottom line as soon as they can. So why shouldn't that constitute waiver? I mean, there was nothing done here that surprised you.
We expected to have a hearing because a hearing was required by law. In fact, the case law shows that allowing administrative. The case law shows that it's very, very rare for an administrative body not to hold a hearing, and the only one pointed to in these briefs is one in which the filing was illegal on its face, and therefore the commissioner had no choice but to reject it. And that standard has not been met here. There are plenty of issues that could have arose in a hearing, and therefore it was necessary before this particular filing was approved.
Could I just change subjects on you because the time is starting to run? But with respect to the evidence on the hurricane models, was there any Lanigan-type hearing, Commonwealth versus Lanigan-type hearing as to the appropriateness?
In the administrative proceeding, that hearing wasn't necessarily. We had several experts on hurricane models as part of the hearing. We had experts that testified for the reliability of these models and those that questioned these models.
So the Lanigan-type issues were fully vetted below?
That's correct.
Okay.
However, the commissioner in this instance did not rely on this sort of expert testimony, but made her decision based only on these models' use in the voluntary market. And this is not enough to satisfy her legal requirement to determine that this rate and how these models are used in this rate is appropriate. She needs to determine.
There's enough in the record for us to make that determination.
But we don't know if she would have made that determination, but for the fact that they are used in the voluntary market.
She might have made the right decision for the wrong reason. I take it there's enough in the record for us to make the decision.
We argue below that there was not enough to determine that this was for her to rely on these models. You know, I know this is not a substantial evidence argument, but that's because the commissioner didn't get that far. She looked at that evidence and questioned it in her decision. She said these models may not be perfectly calibrated to the Massachusetts conditions. She said that there are many issues with vulnerability in these models. She even questioned the reliability of the MPIUA's own witness. However, she says that because these models are used in the voluntary market, she can approve them. And she cannot abdicate her responsibility to review these models as they apply here.
Isn't that another way of saying, though, that they're generally accepted by the industry or generally accepted in the scientific community or, in this case, the business community?
She can say that, but we don't know if these are the same models and calibrated in the same way. We can't say just because some models are used in the voluntary market that some models can be used in this filing. It's not enough here. If she wants to look to the voluntary market, she has to determine that these are the exact same models. They're calibrated the same way as these models, and the data is entered in the same way. But she didn't do that. More
testimony that these models are generally accepted in the industry?
Yes, there was testimony to that extent.
I think even your witness testified to that extent.
That's correct, but she still needs to make the determination that not only are they used in the industry, but in this proceeding, she has to determine that they're actually appropriate to use in this circumstance. She can't abdicate her role to review these models by looking at the market. The market is broken here, which is why they have the FAIR plan, which is why they have this process to make sure that rates are not, that extra costs aren't passed on to consumers who have no other choice but to buy this insurance. Looking at the voluntary market is not enough. The FAIR plan was designed to cover a vulnerable part of the population who has to insure its own houses. This particular statute was required her to review every component so that these people are being charged fairly. This did not happen.
Well, she scaled down, actually, in lots of respects, a lot of the different rate requests. I mean, it's not that she just rubber stamped this. In fact, she rejected the rates for a whole bunch of reasons. And she also rejected the request that they be retroactive. I mean, a whole series of things to ensure that extra costs were not down. She just didn't do as much as you wanted.
She didn't do as much as legally required, and then allowed for a significant portion still to remain unreviewed.
Mm-hmm. Thank you, Ms. Bookman.
Thank you.
Mr. Lyon.
Thank you, Chief Justice Marshall, members of the court. I'm John Ryan. I represent the Commissioner of Insurance. With me today is Julie McElharney, counsel to the Commissioner. The court, I think, is aware that this case breaks down into two general categories, procedural on the one hand, and then an interpretation of the new statute on the other. If we take the procedural issues first, it's quite clear that everybody who participated in the original hearing was clearly put on notice by the Commissioner as to what could be done to salvage all that had gone on in the way of testimony and evidence. In her first decision, the June decision, she gave the FAIR plan an option. You can either refile, making certain corrections to the non-model losses and certain corrections as to the reinsurance allowance, and I will approve it. Or, after 30 days, if you wish, you can file a totally new filing, and, I think importantly, that notice said, if you do that, it will be subject to the Administrative Procedures Act. Certainly the Attorney General and everybody else who participated in the hearing was put clearly on notice by that a revised filing that met the two criteria that the Commissioner set forth would in fact be approved without following the Administrative Procedures Act. And I suggest to you that there was no reason to follow 30A with the revised filing because all of the issues and all of the evidence had been carefully examined in the original series of hearings, which, as the record reflects, ran some 19 days and has some 6,000 pages of data.
I take it you would say, or you might say, that the only possibly contested fact that remains as a result of the second filing is whether, in fact, MPIUA did purchase the reinsurance policy. That's the only, if there's any fact that remains to be litigated, it's that one.
Yes, that is the only fact that it was at all open, and it was attested to by the president of the FAIR plan, an officer of one of the largest, we'll call it an insurer in the Commonwealth, and it was attested to as well by the reinsurer and its intermediary, which gave the Commissioner full evidence as to what companies were participating, at what layers, and how much premium was allocated towards each layer.
Difficult for me to understand, Mr. Lyon, how that could have been contested. In other words, I mean, you can bring the people in, you can, produce the original contract, but I don't think there's a serious claim here that reinsurance doesn't exist, or is there?
Well, I don't think it's a serious claim at all, because it's the kind of evidence that reasonable people rely upon in making important decisions, which is the standard under 30A.
As I understand it, that may be the only thing, but as I understand the Attorney General's argument here, she's now saying, well, I want to see what kind of insurances and reinsurance and whether the costs are appropriate and so on and so forth. But as Justice Cordy's question seemed to suggest, the Commissioner had laid that out, as it were, beforehand, and once those were met, I mean, the Attorney General or anybody else could have objected to that.
Well, the Attorney General in the underlying hearings had all the opportunity in the world to get into whether $13 million was an appropriate allowance if some amount of money was paid for the reinsurance. She declined to do so, and I suggest that her appeal here is really litigator's remorse, to use that term. The opportunity was there, and it was not followed up. Now, to say, well, we could have put Mr. Golembeski, the president of the FAIR Plan, on the stand and asked him if he purchased it, since he had already filed an affidavit to that effect, I sincerely doubt that there would be any question as to what the answer was. And so it could be contested, but it doesn't seem to me it could be successfully tested. And I suggest that that falls within the case law, for example, outdoor advertising, where on its face the refiling shows that the criteria set out by the Commissioner had been met. There's no need for a hearing. Or as said in the AIM case, there's no need to have a reexamination of issues already decided.
Could you turn to the substantive question, which does seem to be an oddity in the statute, the notwithstanding language? I mean, you've got these caps,
Yes.
Caps.
I think it's very important, first of all, that you recognize what it appears rather clearly when you go through both the analysis of the language and the legislative history, what was done here. The legislative history, which I think is appropriate for this court to consider, shows very clearly that the legislature started out with a concern over the adverse effects that the cap was having on the FAIR Plan and sought to do something about it. Thus, the very first statute, or draft statute, said that, in effect, there's a cap, but whenever a filing is made, the Commissioner shall increase rates by at least 2% in the cap territories. It's followed by a redraft that changes that 2% to 3%. And then it is ultimately followed after it passed the House, went to the Senate, and was amended by the language that's now in the statute. So all of the history shows that the legislature was out to give some kind of relief from the cap. And it's important, I think, to note an effect that the cap has on the FAIR Plan, particularly when, as here, the industry as a whole has had relatively good experience over a number of years, partially, I suggest, because they don't write any coastal property and there haven't been any hurricanes. But in any event.
Well, there have been hurricanes, not
Major ones.
not major ones.
Yes, but the last hurricane, 1991, and since then there haven't been any. But I think what's important is the cap is tied to the increases that the voluntary insurers get in their rates. And if they don't look for increases, the FAIR Plan can't come along and get one. And that, I suggest, explains why the legislature started out mandating at least 2%, mandating at least 3%. And then it dawned on them, I am reasonably sure, that you can't mandate an increase every time there's a filing. There may be circumstances that would come along that put the Commissioner in a position where she doesn't feel she wants to give a 3% increase.
Could I just shift subjects and ask you about the whether the statute requires express findings on the question of lost data? I know that there's a statute 175-113B which talks about, which says that the Commissioner must, quote, explicitly consider certain factors. This statute doesn't use the word explicitly, but in the divorce context, in Chapter 208, Section 34, a probate court judge is required to consider certain factors before requiring or before dividing a marital estate in a divorce case. And I think that we've said that they have to actually consider each of the factors, lay them out in their decision.
But I think that's different from what is involved here. First of all, 174A, 175A, and 175C all apply to this particular rate-setting process. And there are a number of things set out in those statutes saying that the commissioner shall consider, none of which historically have been referred to, and none of which are referred to in this particular case. So I don't believe that whatever the reason for Chapter 208's requirement apply here. It's a guidance to the commissioner of the things that she ought to consider. But 113B, being an insurance statute, first of all has two elements. It calls for explicit consideration, and then it calls for detailed explanation of what came from that consideration. So the argument is that if the legislature wanted to do that, certainly in the insurance context, they had done it before. And there is the case, the Aetna case, I believe, is cited in our briefs, which talks about that as being an explicit requirement. So I think it is different. Now, to go back, if I may, to the statute, Justice Spina, it seems to me, in addition to this history, which is very powerful, that we have the notwithstanding language. And notwithstanding, the Cisneros case in the U.S. Supreme Court, I think, marks that term as a very, very powerful preposition. I mean, when you say notwithstanding something, you're saying ignore what I just said and do this. Now, what does it call for the commissioner to do? It doesn't just notwithstanding the cap. It says notwithstanding the cap, the commissioner shall consider predicted hurricane losses, the cost of reinsurance. But it doesn't stop there. It goes on to say approving fair plan rates. I suggest the term when or in ought to be put there to make the sentence meaningful. So legislature started with a desire to do something about the cap, didn't want to mandate what should be done, left discretion to the commissioner what to do by saying to her, notwithstanding this cap, which had been in effect prior to this amendment, you are to consider hurricane losses, cost of catastrophe insurance when you approve such rates. And I say that the analysis that the commissioner made is a sound one. On top of that, her analysis in this circumstance, I think, is entitled to great deference. We have to look at why we give administrative agencies deference when they interpret statutes. Here was the commissioner with a brand new statute, first hearing under it, required to make a decision as to how it applied. She had two parties, one saying this is how it applied, the other saying that's how it applied. She saw it as opaque, to use her term, and then she figured it out. She said this has to mean something. It isn't just in the legislation as one more shall consider kind of thing. It's in the legislation as some type of change from the cap. And if there's any doubt that the commissioner understood that the cap was a problem, I would refer you to her 2004 report to the legislature, which is in the record. As a matter of fact, the record appendix at page 144, where she notes that the effect of the cap up to that point in time is to deny the fair plan adequate rates. That's a report she made to the legislature. With the legislative history and with her interpretation, it all comes down to, look, at the cap isn't working. It's causing problems. We can't have a fair plan that goes bust the next time there's a hurricane. There has to be some relief, and that's what the legislature provided.
Could you comment a little bit on the Attorney General's arguments regarding the use of the models accepted in the private market?
Yes. First of all, I think that the very fact that these types of models are used in the private market is itself substantial evidence that warrants a conclusion that they can be used by the fair plan. Secondly, and it's common sense, it's a matter of fact that if everybody in the business is doing this, just like everybody in the business now follows the internal rate of return that this court approved a couple of years ago in filing profit allowances and so forth, it makes sense that this is a technique that has merit to it. Now, it's very interesting, and one of the justices did comment, I believe, that, of course, the AG's own expert used the model. He not only used the model, he used an AIR model, the AIR model, and he gave it 75% standing against 25% standing for the historical loss information. And I suggest to you that to say that there's something wrong with models when your own witness makes it such a substantial part of his analysis just doesn't wash. The models have been carefully vetted. They've met the Lanigan standards, which the court asked about. Witnesses discussed them in great detail, and there seems to be no reason that can be articulated as to why the commissioner was not perfectly appropriate in making her decision in that regard. I will defer and leave the rest of my time to Mr. Kelly.
Kelly. Thank you, Mr.
Thank
Ryan. Mr. Kelly?
Thank you, Madam Chief Justice. And may it please the Court, I am Cameron Carey. I represent the MPIUA in this case, as I did before the Commissioner of Insurance. And I think from that standpoint, I would like to stress a couple of things in the record and the context for this case. The 2004 legislation, as Mr. Ryan has ably illustrated, was intended to deal with the unintended consequences of its predecessor, the amendment of the Fair Plan Statute, Chapter 175, in 1996. And those unintended consequences were to compound a market failure of availability in the coastal areas and to suppress the Fair Plan coastal rates and to suppress them relative to those insurers that were writing risks on the coast and relative to the risks, relative to the actuarial indications. And the Commissioner's decision here, by adopting the models, dealt with the problem of quantifying that risk and specifically addressed that problem. We have a limited record of reliable data on hurricanes, 104 years worth at the time that this case was heard. That is a moment in meteorological time. And that is compounded by, as Mr. Ryan said, that there has been no hurricane in New England, fortunately, since Hurricane Bob in 1991. And relatively few hurricanes in recent history, very different from, for example, the 1950s. And during that time, the MPIA has not had the coastal risk that it has today. So you cannot, from that record, project the future losses of the Fair Plan, or indeed of any insurer. The testimony of the State Rating Bureau's expert was striking when he said that State Farm Insurance, one of the largest insurers in the country, which has a far more diversified risk than the Fair Plan did, with Hurricane Andrew, lost every single dollar of profit the company had made since the beginning of its existence, trying to rely on history.
I suppose Katrina also is driving a lot of this. Hurricane Katrina.
Absolutely,
And Rita.
Your Honor. We've seen an impact on reinsurance costs and a huge impact on the industry. But I will say that, and this may be going outside the record, that no, actually, I think there is testimony that reflects this from the modeling experts that the industry was able to absorb the losses of Katrina far more easily than it was able to do Hurricane Andrew in 1992, precisely because it was using models and had moved since Hurricane Andrew to away from the reliance on history. What the models do is to deal with the short span of time by projecting hurricane losses over a 100,000-year period, or if you will, to project next year 100,000 times. And the commissioner in this case found that it was reasonable to rely on those models, not just on industry acceptance, not just because they had proved more reliable than history, but based on what the Attorney General has recognized was the extensive record here. When the commissioner found that notwithstanding that the models were not perfectly calibrated to Massachusetts, that they established a reasonable range of loss. That finding specifically addresses the extensive testimony that went into, do the models reflect the frequency and the severity of hurricanes in Massachusetts? Do they reflect the characteristics, the damageability of housing in Massachusetts?
Mr. Kelly, I haven't looked at the models, obviously, but are these national models? Are they regional models? Are they Massachusetts models? I mean,
well, they are national models, Madam Chief Justice, in the sense that they model the entire Atlantic Basin. They take data from the records that have been
but at least it's Atlantic. It's not Pacific.
It is not Pacific. There is a separate set of models, but they then look at and calibrate to each area of the Atlantic coastline the frequency and the severity of hurricanes, and they take into account factors like latitude. The record showed that they take into account different characteristics of storms as they travel north. They lose power, but they get bigger and they travel faster.
If they weren't calibrated to Massachusetts, what region were they calibrated to? How big a coastline was considered?
East. Well, Your Honor, I think the record reflects that while they may not have been fully calibrated to Massachusetts, the commissioner found they were adequately calibrated.
I thought they covered the Northeast. I thought the one in Point covered most of the Northeast.
Well, it covers the Northeast in terms of it looks at the Northeast to calibrate the frequency. So they look at segments of the coastline. Each modeler does it slightly differently. And they calibrate the frequency of the stochastic, the simulated set of storms to the frequency on the historical record. The same as they use the historical record to model the behavior of hurricanes as they travel across the Atlantic. So they're calibrated at each step along the way, and they are calibrated as they make landfall in New England. So they're calibrated most specifically to Florida, which has an extensive review, but also to Massachusetts.
Thank you, Mr. Kelly.
Thank you.